My name is Fred Amon, and I'm the director of the Institute for Advanced Study. And it's my very happy duty today to introduce our speaker, the Honorable Michael Kirby of the High Court of Australia. Justice Kirby is a distinguished citizen fellow of the Institute for Advanced Study, and we are delighted to welcome him back to IU. We're hoping that he's beginning to feel at home here. In 2000, Justice Kirby came to inaugurate a new chair at the law school, the George P. Smith Distinguished Chair in Law, and I'm happy to see George Smith here with us today as well, and a warm welcome to you. And in 2004, Justice Kirby returned to IU as a Branigin lecturer of the Institute for Advanced Study. In his first talk for the Smith Chair, he talked about bioethics and globalization and the work of George Smith. In his second talk, he talked about terrorism and the role that courts were playing around the world, historically and currently. And today, he returns as a distinguished citizen for the Institute, and we are fortunate to have him here indeed, and to hear him again. His previous lectures were published in the Indiana Journal of Global Legal Studies, and they've made important contributions to the burgeoning literature on law and globalization. Justice Kirby is one of those rare judges who can see the global in the particular, and the ways in which law is or should be adapting to a world in which national boundaries don't quite do the same anymore, and in which legal systems are not nearly as autonomous as they once may have been. Wisdom, creativity, fairness, and humanity are the hallmarks of Justice Kirby's jurisprudence. He has helped shape the law in many ways, especially in areas dealing with human rights. His vision and clarity of thought are an inspiration to us all, and I know that they will be an inspiration for generations of lawyers, judges, and scholars to come. Justice Kirby received his Bachelor's of Economics and his Bachelor of Arts and his Master of Law degrees from the University of Sydney. From 1983 to 1984, he was a judge in the Federal Court of Australia, the youngest person ever to be appointed as a federal judge. He then was appointed president of the New South Wales Court of Appeals, the highest court in that state's legal system. And in February of 1996, he was appointed to the High Court of Australia and has served there ever since. He received Australia's highest honor in 1991 when he was made a companion of the Order of Australia, and he's also a companion of the Order of St. Michael and St. George. In the 1990s, Justice Kirby acted as a special representative of the Secretary General of the United Nations for Human Rights in Cambodia, and he served on many other UN bodies. He is currently a member of the International Bioethics Committee of UNESCO, the Ethics Committee of the Human Genome Organization, the Global Panel on Human Rights of UN AIDS. He was among the founders of Australians for Constitutional Monarchy, an organization which played a prominent role in the No Republic campaign during the lead-up to Australia's 1999 Republic referendum. And earlier this year, Justice Kirby received the 2006 New South Wales Australian of the Year Award. He also serves as a dedicated trustee on the board of the Kinsey Institute here at IU, and it is this connection to Kinsey that forms the basis of this talk today, which is entitled Alfred Kinsey and His Continuing Impact on the Human Rights of Sexual Minorities. He will take questions after his talk, and then we'll have a reception to which you are all most cordially invited. Please join me in a warm welcome to Justice Kirby.
Professor Ammon and dear friends and colleagues, Justice Sullivan, Professor Smith, and new friends that I will make today on this beautiful day in Bloomington. As I will reveal, Bloomington and Indiana have played quite an important part in my life, and I haven't been here before in October, It's a little chilly in the mornings, but the trees and the beauty of the place make it clear that this is one of the most wonderful places on God's earth, and I'm sure you who live here fully appreciate that fact. On the 11th of September 2006, the people of the United States of America paused to remember the events that had happened in New York and Washington 5 years earlier. And many others, including in Australia, joined in a reflection on the day that changed the world. On the very same day, a little known noticed event occurred in Houston, Texas. Tyron Garner, a homosexual man aged 39, died of complications of meningitis. Newspaper reports told of how he'd been one of the accused with John G. Lawrence, who'd been arrested in September 98 and charged with violating the Texas homosexual conduct law. The arrest was effected by a sheriff's deputy who claimed to have witnessed the two men engaged in an act of sodomy. Mr. Garner and Mr. Lawrence had been alone in the apartment when a tip-off claimed that a black man was going crazy in the apartment and was armed with a gun. When the police arrived, there was an open door, no affray, no gun, simply two adult men in a bedroom engaged in consensual sex. The deputy sheriff arrested the men and charged them with sodomy. On legal advice, they pleaded no contest. They successfully challenged their convictions before a three-judge panel of the State Appeals Court. However, that decision was reversed by the state's Supreme Court. Its order resulted in an appeal to the Supreme Court of the United States, and by a 6-3 majority, that court, in Lawrence against Texas, quashed the convictions. The opinion of the Supreme Court was written by Justice Anthony Kennedy, and at the close of his reasons, Justice Kennedy explained the evolution of the Supreme Court's consideration of the legality of homosexual criminal offences in this country. He said this: "Had those who drew and ratified the due process clauses of the Fifth Amendment or the 14th Amendment known the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew times can blind us to certain truths, and later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. As the Constitution endures, persons in every generation can invoke its principles in their own search for greater freedom." Even more important than for the decision on the specific subject of the constitutionality of sodomy offences was the significance of the Lawrence case for the citation by the Supreme Court of legal materials from foreign jurisdictions tending to point in the direction in which the majority were moving. In this respect, the decision in Lawrence reflected other recent decisions of the Supreme Court of the United States, in which a majority has examined judicial materials from international and national courts concerned with issues similar to those before the Supreme Court of the United States under the United States Constitution. Specifically, Justice Kennedy made reference to decisions of the European Court of Human Rights, striking down homosexual offences in 3 countries of the Council of Europe bound by the European Convention on Human Rights. Now, many lawyers and not a few judges raised in the strict confines of their national or subnational jurisdictions object to the thought, and even more the practice, of using legal reasoning from other countries in any way in the elaboration of their own national constitutions and laws. The basic difficulty for legal nationalists who wish to confine and restrict the ideas and reasons deployed in the elaboration of national constitutions and laws is the fact that today the world has moved on, ideas are now constantly circulating across national boundaries with an inevitable impact on the minds of human beings and the way in which they perceive the world, its people, and its legal, political and social problems. In a time of satellite television, jumbo jets, the internet, cell phones and global media, it's virtually impossible in most civilized places to stem the incoming tide of global discussions about science, truth, values and perceptions of our planet. Some writers contend that the events of September the 11th, 2001 evidenced a clash of civilizations. Writing 8 years earlier, Professor Samuel Huntington predicted a growing cultural division between Western Christianity and Islam. He suggested that this clash represented the new fault line that was replacing the old fault line between the liberal Western democracies and Soviet-style communism. When September the 11th, 2001 occurred, the notion of a new fault line evidencing a different clash of civilizations gained a lot of attention. Adhering to this thesis of the clash of civilizations, many writers suggest that the Muslim world lacks the core political values that gave birth to the representative democracy of Western civilization, namely separation of religious and secular authority, the rule of law, social pluralism, parliamentary institutions of representative government, and protection of individual rights. However, more recent research by Professor Ronald Inglehart at the University of Michigan and Pippa Norris of Harvard University suggests that what they call the true clash of civilizations is not between Islam and the rest, it's between the values of modern, secular, democratic societies and the values of other societies, often influenced by fundamentalist or theocratic religious views about the world and its people. According to this new view, the cultural divide of contemporary societies is between values that are held concerning what Inglehart and Norris call the sexual clash of civilizations. By reference to a world values study which they've conducted, the core clash is not over political values as such. Upon such questions as the desirability of democratic institutions, the values expressed in the responses to the World Survey, both in Western and in Islamic countries, are roughly similar. Instead, the fault line seems to be closely linked with ideas of modernisation. It's connected with attitudes to such issues as gender equality, the right to divorce, contraceptive rights and abortion, and most especially the issue of homosexuality. Upon these issues, there remain strongly divergent views as between the majority of Western democracies and other countries of the world. Specifically addressing homosexuality, Inglehart and Norris conclude in this way, quote, "The way a society views homosexuality constitutes a good litmus test of its commitment to equality. Tolerance of well-liked groups is never a problem. But if someone wants to gauge how tolerant a nation really is, find out which group is the most disliked, and then ask whether members of that group should be allowed to hold public meetings, to teach in schools, and to work in government. Today, relatively few people express overt hostility to other classes, races, or religions, but the rejection of homosexuality is widespread. In response to the World Survey question about whether homosexuality is justifiable, about half of the world's population say never. But as is the case with gender equality, this attitude is directly proportionate to a country's level of democracy. Amongst authoritarian and quasi-democratic states, rejection of homosexuality is deeply entrenched. 99% in both Bangladesh and Egypt, 94% in Iran, 92% in China, 71% in India. By contrast, these figures are much lower among respondents in stable democracies, 32% in the United States, 26% in Canada, 25% in Britain, and only 19% in Germany. The authors point out that Muslim societies are neither uniquely nor monolithically low in tolerance towards minority sexual orientation or gender equality. Many of the successor Soviet states rank as low on these issues as most Muslim societies. Nevertheless, on the whole, on these issues, Muslim societies lag behind the West and behind almost all other societies as well. And most significantly of all, the figures reveal that the gap between the West and Islam is even wider among younger age groups than amongst the older. How then did this wider civilization, to which Justice Kennedy referred in the Lawrence decision, spread on these issues to Western societies, and specifically on the issue of homosexuality? How did they take hold in such a relatively short time, half a century more or less, and why did that happen? It's when scholars talk about the sexual clash of civilization as an explanation of the divide that now exists in the world, thoughts naturally turn to the work of Dr. Alfred Kinsey at this university, a work that's continuing today in the Kinsey Institute. For the past 5 years, I've been privileged to serve on the board of the Kinsey Institute, and I must say I've been surprised at how modestly the Institute is funded, how modestly it's often appreciated for its enormous impact on the world in one of the pivotal ideas of our time, at the fault line, as it's said, of modern civilizations. In the remainder of my remarks, I want to say something about Dr. Kinsey and his research. I'll then contrast some of the earlier decisions of the Supreme Court of the United States relating to homosexuality and the decision in Lawrence. My central thesis is that Dr. Kinsey and his institute is not that they single-handedly revolutionized the values of contemporary Western societies towards homosexuality or any other sexual issues, but it is that Kinsey's research profoundly shifted the debate in the United States of America and hence in other Western countries. Moreover, the research within the area that Kinsey and his colleagues undertook at this university should be seen as very important to the true fault line that exists in the world today. If progress is to be made in human civilization, it must come in areas such as gender equality, rights to divorce and contraception, and attitudes to homosexuality. If the world is to become a more tolerant and therefore a safer place, this is where progress has to be achieved. And this is why Kinsey is not only important to America and its laws, the subject matter of the research into human sexuality addresses a very important issue for our world and is therefore important to the future of the planet and of the species. It's exactly 50 years since, in August 1956, Dr. Alfred Kinsey died. He was born in Hoboken in June 1894. Both of his parents were deeply religious, and during his youth the family were members of the Methodist Church. He was gifted in poetry and music as well as in his studies. He joined the Boy Scouts of America soon after their founding in 1910. He chose to study biology, and he soon excelled in zoology, as that branch of the science was then known. He took his Bachelor of Science degree, magna cum laude, and proceeded to the Harvard Graduate School and chose gall wasps as the insect that he was going to study intensively. In 1920, Dr. Carl Eigenmann, chairman of the zoology department of this university, invited Kinsey to Bloomington for a teaching job. The university was celebrating its centenary year. It had an enrollment of 2,296 students all up, of whom only 37 came from out of the state and 50 were engaged in graduate studies. Despite an initially unfavourable impression of Bloomington, you wonder how that could happen, he cast in his lot with Dr. Eigenmann. He began to work as an assistant professor. He rose to be associate professor in 1923, and in 1929 he was appointed a full professor of Indiana University. In 1920, Kinsey met Clara Macmillan at a zoology picnic. He courted and married her in June 21. Their children, Donald, Anne, Joan and Bruce, were born in 1922 and 28. Kinsey taught undergraduate general biology, but he continued his research into the gall wasp, and he did so effectively that he became a world expert on that insect. Now, Kinsey's obscure but worthy scholarly life might have continued in Bloomington in this way, but for one of those curious shifts of the mind that mark out the greatest of scientists. By the mid-1930s, he became very interested in the life views of great men of science. Perhaps it was reflecting upon such great scientists and the breakthroughs of their mind that led Kinsey into a new field of biology concerning what he called the human animal. He later claimed that it was work of Dr. Robert Dickinson, an American leader in sex education, maternal health and birth control, that first made him interested in sex research into humans. In 1938, he began a marriage course for undergraduates and others at this university. Predictably enough, this attracted opposition from conservative circles, but it was supported by the trustees. By the late 1930s, he was working on biometric treatment of data, translating the same meticulous scientific methodologies he had perfected in studying gall wasps, so far as it was possible, into the study of human sexual behaviour. As you all know, books have been written, plays have been staged, documentaries and films have been screened concerning the way Kinsey began his program of research in prisons and elsewhere. One of the early ideas that evolved from his thousands of interviews was that the previous assumption of a strict binary division between homosexuals and heterosexuals was in fact scientifically inaccurate. Kinsey was beginning to postulate a rating scale by which individuals could be ranked at different points in relation to sexual behaviour, sexual inclinations and interests. This was a case of a taxonomist working on a taxonomic problem. The methods remained exactly the same as with the gall wasp, only the subject material had changed. Kinsey's questionnaire format was developed in the 1940s. From the beginning, it covered questions on major sexual outlets of human beings, masturbation, sex dreams, petting, coitus, and the last were subdivided into categories based on the identity of the sexual partner. This allowed for subclassifications including premarital, marital, extramarital, postmarital coitus, and intercourse with prostitutes. Kinsey added one particular sexual activity, namely homosexual relations, to his research, and it was quite unique. No one with such methodological precision had ever before attempted such a systematic study of the human sexual experience. People of my age who came to mature consciousness in the 1940s and 50s can remember the mood and attitude of those times. Back in Australia, as in America, they were years fiercely resistant to research of the kind that Kinsey had embarked upon. That research challenged not only religious precepts, but also community notions of civic morality, public modesty, marital privacy, basic decency. In Australia in the 1950s, a leading police commissioner, Colin Delaney, later named as the Australian Father of the Year for 1960, declared that homosexuality was, quote, Australia's greatest menace and fastest growing crime. Rounding up these criminals, entrapping them, putting them on the front pages of the newspapers, naming and punishing them was one of Commissioner Delaney's obsessions. And he had his counterparts in America, in Britain and elsewhere. In fact, they still exist in many parts of the world. Only an obsessive scientist with a background in gall wasps would have led his colleagues and this university and the world into such a taxonomic minefield. I'm not going to recount again the fierce opposition to Kinsey's research from churches, politicians, fellow academics, civic groups and others. His work on human sexuality only really survived because of the strength of his personality, the support of his wife and his immediate colleagues, and the unwavering insistence of the president of Indiana University, Dr. Herman Wells, that the university existed both for teaching and for the search for truth. When the history of academic independence, its enemies and noble protectors is told, the stand taken by Dr. Wells, who for the most part maintained the support of the University Board of Trustees, represents one of its finest moments. It would have been easy, even perhaps predictable, for Indiana University and Dr. Kinsey to have buckled under, especially when, in an earlier moment of paranoia, Kinsey was accused of actually aiding communism. But the buckling never happened, largely because of the powerful personalities of Kinsey and Wells. It says a lot about the basic integrity of the American university tradition by the 1950s, and of Indiana University in particular, that Kinsey's work went forward. His first major report, published in 1948, was Sexual Behaviour of the Human Male, and the second report, in 1953, was Sexual Behaviour of the Human Female. Each report, but especially the first, burst on the world as an intellectual bombshell of new ideas. Each report challenged assumptions that were generally accepted throughout the world concerning the facts of human sexual experience. Each undermined the strictly binary notions of sexual orientation. Each demonstrated widespread human inclination to sexual variety, experimentation and experience of various kinds during life. According to Yale professor William Eskridge and his co-author Professor Nan Hunter, in the 1948 report, quote, remains the most comprehensive empirical study of male sexuality in America, today, 60 years later. The research of Kinsey and his colleagues revolutionized thinking about sexual behavior, both in the United States and far beyond. The Kinsey approach focused on comprehensive fact-gathering from a large but non-random sample of college students, prisoners and Indianans swept into the giant study of the Kinsey Institute. The study of male respondents concluded, quote, males do not represent two discrete populations, heterosexual and homosexual. The world is not to be divided into sheep and goats. It is a fundamental of taxonomy that nature rarely deals with discrete categories. Only the human mind invents categories and tries to force facts into separate pigeonholes. The living world is often a continuum in each and every one of its aspects. The sooner we learn this concerning human sexual behaviour, the sooner we will have a sound understanding of the realities of sex. Amongst the most surprising findings in the 1948 report concerned homosexuality. Until that time, American psychologists, Freudian and otherwise, and their counterparts worldwide, had depicted homosexuality as biologically abnormal and psychologically poisonous. The Kinsey findings cast doubt at least on the rarity and abnormality of homosexual orientation. According to them, 37% of the male population had at least one overt homosexual experience between the ages of 16 to 45, whilst another 13% had reacted erotically to other males without having an experienced orgasm. This meant that 50% of the male population, according to Kinsey's data, had experienced homosexual erotic attraction during adulthood. 10% of the male population had been more or less exclusively homosexual for 3 years, and 4% of the white male population that he studied were exclusively homosexual for their entire lives. The findings in the 1948 report concerning heterosexual activity were almost as surprising. Contrary to the then accepted mores, Kinsey and his colleagues found that virtually all men masturbated even after they were married, that many husbands had sexual affairs after their marriage, and that married couples engaged in a range of sexual activities, including oral and anal sex. The 1953 study on the human female reported significant but lower homosexual attraction and activity amongst women. It found that 28% of women sampled had experienced significant erotic attraction to other women, compared with the 50% in the male sample. But Kinsey's great contribution to the study of women's sexuality was to establish beyond reasonable doubt that women are sexually active rather than purely passive by nature. Nearly 50% of the sample had engaged in premarital intercourse, a considerable portion with their fiancé in the year or two before marriage. This discovery, unremarkable in today's society, came as a very great shock in 1953. Among married couples, women tended to be more interested in intercourse later in marriage, while men tended to be more interested in it earlier in marriage, and 26% of women had engaged in extramarital coitus by the age of 40. The incidence of such intercourse in women was affected by their religious background more than any other character. Kinsey's research findings confronted social hypotheses that were the foundation of much religious and other moral instruction at the time. They challenged the assumptions about fellow citizens and human beings held by most people. They challenged the laws that gave effect to social postulates and sexual experience. These laws concerned such matters as the woman's role in marriage, her subordination to the rights of her husband, very different entitlements to divorce, the woman's entitlement to forms of contraception to control reproduction and to prevent unwanted pregnancies, and the operation of anti-sodomy laws and laws against so-called unnatural offences designed to stamp out such abominable crimes, which one judge in Georgio in 1904 had declared to be, quote, not fit to be named amongst Christians. Growing up in a world which for centuries had perpetuated notions about abnormality, unnaturalness, rarity and offensiveness, and indeed abomination of the homosexual inclination and the acts to which that inclination gave rise, you can imagine the impact that the widespread reporting of Dr. Kinsey's research occasioned in my life down there in sunny Australia. Reaching puberty in about 1950, I didn't have to confront a belief in the wickedness of my own homosexual or inclination, which somehow seemed perfectly natural to me, in quite such a lonely state as would have been the case before Dr. Kinsey's report was made public. Confronted daily by the denunciations by Police Commissioner Delaney, and reading with wide eyes the front page stories of the arrests in Sydney for sexual indiscretions of the chief conductor of the Sydney Symphony Orchestra, Sir Eugene Goossens, and a famed visiting international pianist, Mr. Claudio Arrau, it was a calming thing to learn that I wasn't, after all, alone. I was probably, at the age of 11, not even intrinsically evil, as some churches were inclined to say, even if Dr. Kinsey's research wasn't totally accurate, down to the very last percentile, and even if Australians were not as sexual as their American cousins, the overall result seemed probably capable of extrapolation, even in my young mind at the age of 10 or 11. What had been taught for centuries, even millennia, was simply not being borne out by the empirical research into actual human behaviour. Human beings were, it seemed, very sexual creatures. This was a vital insight, and for me and for millions of others, heterosexual as well as homosexual, it came with a very powerful impact. In fact, the changes that then occurred in social attitudes and in laws happened pretty quickly. In part, this was because of the great debates over the very purpose of human society and of the criminal laws which the Kinsey reports stimulated. In England, they accompanied the Wolfenden Royal Commission and the eventual repeal of the anti-homosexual criminal offences, first in the United Kingdom and then throughout most of the Commonwealth countries. They led to numerous proceedings in the European Court of Human Rights, which gradually and with growing insistence moved to demand and insist that criminal and other discriminatory laws against the homosexual minority in European countries must be repealed. Now, to be a member of the Council of Europe, and hence a member of the European Union with its economic advantages, it's necessary to get rid of criminal laws at the very least. Whilst prejudice and discrimination aren't quite so easily abolished, the worst sources of the oppression were swept away in Europe from Galway in the west to Vladivostok in the east. In South Africa, the new post-apartheid constitution guarantees protection against unfair discrimination on the grounds of sexual orientation, a provision inserted on the insistence of Mr. Mandela on the basis of the faithful support of the anti-apartheid campaigns by the gay minority in South Africa. In Fiji, in Hong Kong, and in other jurisdictions, courts have overruled the criminal laws that discriminate against adult people whose sexual orientation is homosexual or bisexual. Now, in many countries, new laws are coming under fresh scrutiny. In the Netherlands, in Belgium, in Spain, in Canada, Massachusetts in the United States, and likely soon, before the end of this year, in South Africa, the civil status of marriage has been opened up to homosexual partners as well as to heterosexuals. To some, seemingly many, this is a legal step too far and too quickly. A lot of rather unkind things have been said in the ensuing debate. My own partner, Johan, back there in Australia, a partner of nearly 38 years, he and I get by without the formalities. But the fact remains that he is not protected by my judicial pension rights as a spouse or as an opposite-sex de facto spouse would be. In this way, laws still exist in virtually every country that treats sexual minorities unequally. It's a sad realisation to discover that one is the target of legal discrimination, sadder still to find that such discrimination often has the support of large numbers of decent, educated, friendly fellow citizens. Nevertheless, big changes in the law and in society have undoubtedly been made in the 50 years since Dr. Kinsey's death. He's not alone responsible for the changes, but his research encouraged other investigations casting doubt on the previously accepted generalisations about homosexuals. The process of change has to start somewhere, and change, if it's to come about and to endure, has to be founded on the best possible scientific data. Essentially, this is what Dr. Kinsey did at Indiana University by bringing about his national debate and eventually a global debate. His work coincided with a propitious moment in human history. It profoundly influenced the thinking of people who grew up as I did at the time of the two Kinsey reports, and carried in their minds thereafter the unforgettable message about the variety of human sexual experience and the significant ordinariness of that variety. Once that message was perceived and digested, it became increasingly harder in law and in society to go back to attitudes of oppression and hatred. The seeds of individual and social change were planted, and a very big part of that change began here in this quiet place in Bloomington. This brings me to the changing course of decisions of the Supreme Court of the United States in cases involving sexuality over the past 60 years. Time doesn't permit an examination of the course of the decisions on matters such as gender, contraception, abortion, marriage and divorce, but it is worth noting some of the features of the evolving law in the Supreme Court and the reasoning on the cases concerning homosexuality. Not unnaturally, they reflect over the decades since the 1950s the changing attitudes on this subject in the United States more generally, showing what a long way it has travelled since the attitudes of that Georgio judge back in 1904. An early decision after the Kinsey report was the decision in Boutillier against the Immigration and Naturalisation Service. That was a case where Mr. Boutillier, a Canadian national, first admitted to the United States in 1955, applied for American citizenship in 1963. In his application, he disclosed a 1959 arrest on a charge of sodomy, later reduced to simple assault, and later still dismissed on the default of the complainant. He revealed that since 1959 he'd shared an apartment with a man who was his occasional lover. An affidavit from a professor of psychiatry deposed that he had sexual interest in girls and that his sexual structure was still fluid and immature. However, he was refused citizenship of the United States on the basis that within the statute he was, quote, afflicted with psychopathic personality under the Act. He challenged that finding and the constitutionality of the Act. His challenge failed ultimately in the Supreme Court. The opinion of the Supreme Court was delivered by Mr. Justice Clark. He found that there was substantial support in the record for the finding of the statutory disqualification, and he rejected the due process argument. Justices Brennan, Douglas and Fortas dissented. In his opinion, Mr. Justice Douglas quoted extensively from the Kinsey report, specifically the statement in the 1948 report that, quote, many of the socially and intellectually most significant persons of our history, successful scientists, educators, physicians, clergymen, businessmen, and persons of high position in governmental affairs, have socially taboo items in their sexual history, and amongst them they have accepted nearly the whole range of so-called sexual abnormalities. Justice Douglas cited the statistics of the American male population that had had a homosexual experience, according to the Kinsey report, and added in language that was then thereafter to recur in the Lawrence decision, quote, the sponsors of Britain's current reform bill on homosexuality have indicated that 1 male in 25 is a homosexual in Britain. To label a group so large as excludable aliens would be tantamount to saying that Sappho, Leonardo da Vinci, Michelangelo, André Gide, and perhaps even Shakespeare, were they to come to life again, would be deemed unfit to visit our shores. The minority concluded that even if the statute were not unconstitutionally vague, it could not be applied to the appellant because he was not within the statute afflicted with a psychopathy. It was an important assertion by the minority in the highest court of the essential normalcy, as they saw it, of homosexuality. And it was based squarely on Alfred Kinsey's findings and their influence both on the justices' knowledge and reasoning. To illustrate the extent of the progress made, Professors Eskridge and Hunter in their book, quote, observe, the irony of Boutillier is that the liberal Warren Court went out of its way to interpret the spongiest statutory term in the most broad and anti-homosexual way. Note that the liberal Chief Justice Warren and Justice Hugo Black voted with the majority. The future liberal Justice Thurgood Marshall was the Solicitor General who defended the position taken by the liberal administration of President Lyndon Johnson. This much is apparent. Liberals, as well as conservatives, agreed that homosexuals were mentally ill. Doubtless hoping that things had improved in the passage of the next 20 years, in Bowers and Hardwick in 1986, the appellant challenged the constitutional validity of the Georgio Sodomy statute, presumably the one referred to by the judge in 1904. He asserted that the statute placed him as a homosexual in imminent danger of arrest and violated the federal constitution. The district court rejected his claims. The 11th Circuit Court of Appeals reversed and accepted his claims, but the Supreme Court reinstated the district court's judgment. Delivering the opinion of the majority in the Supreme Court, Justice White remarked, quote, Precedent aside, the respondent would have us announce, as the Court of Appeals did, a fundamental right to engage in homosexual sodomy. This we are quite unwilling to do. Prescriptions against the conduct have ancient roots. Sodomy was a criminal offence at common law and was forbidden by the laws of the original 13 states when they ratified the Bill of Rights. In 1868, when the 14th Amendment was ratified, all but 5 of the 37 states of the Union had criminal sodomy laws. Against this background, to claim that a right to engage in such conduct is deeply rooted in the nation's history and tradition, or implicit in the concept of ordered liberty, is at best facetious. Chief Justice Burger was even more strident in his opinion. Quote, Blackstone described the infamous crime against nature as an offence of deeper malignity than rape, a heinous act, the very mention of which is a disgrace to human nature and a crime not fit to be named. To hold that the act of homosexual sodomy is somehow protected as a fundamental right would cast aside millennia of moral teaching. Justice Blackmun, with whom Justices Brennan, Marshall and Stevens joined, dissented. Quote, It is precisely because the issue raised by this case touches the heart of what makes individuals what they are, that we should be especially sensitive to the rights of those whose choices upset the majority. In 1995, a challenge was brought to the constitutionality of an anti-homosexual measure, Amendment 2, passed by the statewide voters in Colorado, winning 53% of the vote. The amendment forbade any law whereby homosexual conduct, practices or relationships have protected status or against a claim of discrimination. In Romer and Evans, decided in 1996, the Supreme Court agreed to consider the constitutionality of the Colorado measure, and the justices voted 6-3 to strike down Amendment 2 as unconstitutional. The majority comprised Justices Stevens, O'Connor, Kennedy, Souter, Ginsburg and Breyer. Chief Justice Rehnquist and Justices Scalia and Thomas dissented. Quoting the famous opinion of the first Justice Harlan, dissenting in Plessy and Ferguson, Justice Kennedy for the Supreme Court said, 1 century ago, the first Justice Harlan admonished the courts that the Constitution neither knows nor tolerates classes among citizens. Unheeded then, those words are now understood to state a commitment to the law's neutrality when the rights of persons are at stake. The Equal Protection Clause enforces this principle and today requires us to hold invalid a provision of Colorado's Constitution. And he went on, we cannot accept the view that Amendment 2's prohibition on specific legal protections does no more than protect homosexuals deprive homosexuals of special rights. To the contrary, the amendment imposes a special disability on those persons alone, singling them out. The minority of the Supreme Court castigated this opinion, pointing to what it was suggested was an inconsistency between the recent ruling in Bowers and Hardwick and the new ruling in Romer and Evans. Justice Scalia declared that the court has, quote, mistaken a Kulturkampf for a fit of spite. For the minority, this was an impermissible intrusion by the Supreme Court in the rights of democratic government to express the disapproval of citizens as to the homosexual lifestyle. In 2000, in Boy Scouts of America against Dale, the balance appeared to slip backwards. However, a strong dissent was filed in Dale by Justice Stevens, ever consistent on this issue. Justice Souter, joined by Justices Ginsburg and Breyer, also dissented, explaining their awareness of, quote, the laudable decline in stereotypical thinking on homosexuality, and by 2000 the language on both sides of the judicial divide was much more muted. Chief Justice Rehnquist's opinion acknowledged that, quote, homosexuality has gained greater social acceptance. The radical alteration in mood, outcome and expression can now be best perceived in Lawrence and Texas, the case with which I began this talk. Consider and contrast first the following observations written for the court by Justice Kennedy. Quote, the petitioners are entitled to respect for their private lives. The state cannot demean their existence or control their destiny by making their private sexual conduct a crime. Their right to liberty under the Due Process Clause gives them the full right to engage in their conduct without the intervention of the government. It is a promise of the Constitution that there is a realm of personal liberty which the government may not enter. The Texas Statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual. However, still fighting the Kulturkampf, Justice Scalia was no less emphatic than he had previously been. Quote, "Today's opinion is the product of a court which is the product of a legal profession or culture that has largely signed on to the so-called homosexual agenda, by which I mean the agenda promoted by some homosexual activists directed at eliminating the moral opprobrium that has traditionally attached to homosexual conduct. It is clear from this that the court has taken sides in the culture war, departing from its role of assuring, as neutral observer, that the democratic rules of engagement are observed." End quote. Justice Thomas, who dissented with Justice Scalia and the Chief Justice, took time to observe that the Texan law was, in his view, quote, "an uncommonly silly one," citing Griswold and Connecticut, which as a legislator he would vote against. He simply felt that it must be left to the democratic process and not disturbed by judicial imperatives. The interaction between final courts and the legislative process is an ongoing feature of all government governed by democracy. It's a healthy interaction, and it's one that reflects the debates in the nation itself. It involves constant interaction between the democratic elected element of the Constitution and the principled, reasoned decisions of the courts. The advances that have occurred in law, policies and attitudes to issues such as sexuality derive from a confluence of very powerful forces. Amongst them, I would certainly place very high the impact of scientific research, especially the work of Dr. Alfred Kinsey and his colleagues at this university, now continued at the university by Professor Julia Hyman and her colleagues. Kinsey's research gained worldwide popular attention. They gripped the imagination and interest of millions of people, not only in the United States. They had a profound effect on the Kulturkampf, in part because they were expressed by scientists in the language of scientific taxonomy, and by Dr. Kinsey himself, who proved to be a brilliant, because very understated, proponent of the basic truths that he was uncovering. In addition to this element, the equation for change includes 6 other factors, I suggest, that help to explain the relatively rapid movement in the law, in social attitudes and policies in less than half a century. I refer to the strong tradition of independent research in university institutions, which was defended at Indiana University by President Herman Wells. The strong tradition of free expression and the free media, even where unpopular facts, people and opinion are concerned, that is such a feature of the United States of America. And the rapid advance of mass media and global communications that spread knowledge of Kinsey's research and that of other researchers who followed. Further considerations that combined with Kinsey's research to spread the message include the changes caused by the Second World War and by the universal movement for human rights that followed it, the growing self-awareness in the homosexual community itself, and the support for change that it gradually received from heterosexual friends and family, and the conviction of an ever-increasing number in society that past laws, attitudes and policies on this subject were often irrational and unjust and had to be reformed and changed. Dr. Alfred Kinsey is, in my view, one of the greatest scientists of the 20th century. He's certainly one of the greatest scholars of Indiana University. His contribution to the wider civilization, which Justice Kennedy referred to, should never be understated. He should have more honour than he does in this university, in this state and in this nation. By his research and his ideas, he became a most powerful change agent, and the process of change that he and his institute and colleagues helped to put in place has by no means yet run its course. At the fault line of ideas competing for human acceptance in the current age, Dr. Kinsey stands, beckoning us forward to a greater rationality and knowledge about aspects of ourselves. We like to think that human beings are genetically programmed to embrace and follow rational discoveries. If we fail to do so in an age of weapons of mass destruction, the future of our species must be quite limited. If we listen to Kinsey and other scientists, we can, like the exploring Cassini mission that winds its way through the rings that surround the planet Saturn, take our minds out to the furthest galaxy of the universe and bring them back down to the microscopic world of the human genome. A creature that can map space and chart the genome must have the ability to perceive, study, and understand the truth about itself. It is not asking too much to expect that it do so. This is what Alfred Kinsey demanded and helped us to do. We who follow should listen to his message, to his optimism and confidence, with open minds and open hearts, and especially when we gather together as we do today in Bloomington, Indiana, United States of America. Yeah. Now we'll have some questions. This is your first time and opportunity to ask a Supreme Court Justice some questions. Normally we do the questioning and you sit there and look in awe. But today it's a democratic encounter and you can ask questions or disagree. This is a free and democratic country, and freedom of opinion and expression is cherished by your constitution and your tradition. Are there any questions or comments? Yes.
You talked about the trends moving in the courts of being more and more accepting of homosexuality from a legal standpoint. With more recent conservative appointments to the Supreme Court, do you think there's a potential for a backslide, or at most just a temporary diversion of that trend?
You want me to give a prediction on the future of the Supreme Court of your country. It takes me all my time to work out the direction of the Supreme Court of my country and to work out what is going to happen there. Of course, it is true, and it cannot be denied, that in interpreting a constitution, which is generally expressed in very brief and opaque language, or in interpreting legislation, which is necessarily expressed in the English language, which is inherently a very ambiguous language. The feature that makes our language so wonderful for literature is a feature that makes it very ambiguous. It's the marriage of the Germanic and the French stream. Or in giving effect to the common law, when courts have that responsibility, when no two cases are ever exactly the same, there is a leeway for choice, as my great professor, Professor Julius Stone, taught me. There's a leeway for choice, and values of justices inform the way they make their choices. That cannot be denied. It's part of reality. So I would think that if one were predicting that in all of our countries of the Western community, the progress will continue for homosexual citizens, but it'll probably continue like the progress continued for women and for African Americans, and in Australia, Asian Australians, at a pace that is a sort of journey of enlightenment. And people shouldn't expect miracles overnight. That's not the way a democracy, and it's certainly not the way courts operate. But there have now been a number of very important signposts. They are part of the doctrine of the Supreme Court of the United States, and I would think that justices would be very mindful of those signposts in the way they decide new cases. It's rare that things ever go back to where they were when changes of a great kind occur in constitutional doctrine. So I think it's just a matter of watch this space, and it will be an interesting thing for us in Australia to watch what happens in this country, which often parallels what is happening in my country as well as other countries, but especially in a country like Australia, because our constitution, save for the Bill of Rights, is very similar to the constitutional arrangement of this nation. Yes?
What if you have any notion of why there appears to be such a distinction between Canada and the United States on the issue of gay marriage?
Well,
Canada seems so much further ahead of us. Why that should be?
I can't, not being a North American, I can't really say this except as a foreign observer. I read an article which explained the difference from the fact that the Canadian Constitution, as the Australian Constitution, talks of the charter to the legislature as a charter for peace, order and good government. They get the powers of the federal parliament are given for peace, order and good government of Canada. Whereas the Charter of America has traditionally been for life, liberty and the pursuit of happiness, those ringing words. And it may be just that in the search for peace, order and good government, there's less excitement, but more steady as you go progress. And the Canadians, as you know, having come belatedly at their Charter of Fundamental Rights and Freedoms, are very proud of it. They insisted on having in the Charter a provision that permitted the federal parliament and the states in certain matters to override a charter decision. But my understanding is that that either has never been used or has only been used once because of the tremendous support of the Canadian people for the Charter and for the work and decisions of the Supreme Court, which have been prudent and sensible on the way. Of course, the issue of same-sex marriage was decided at a provincial court level in Canada, and the Supreme Court, when it got a reference on the matter, only really said to the Parliament, we're not saying you have to do this, but if you do it, it will be conformable to the Constitution. And so they left it to the Parliament, and the federal Parliament, as you know, enacted the law. The present Prime Minister of Canada and the new government are committed to putting a bill to repeal that law, and that will come, it is believed, sometime in the new year. Most Canadians that I've spoken to don't expect any repeal of the law, but it's another case of watch this space. But as to why they are different, many people think Canada's a rather boring sort of place, but it's often a very temperate place, I think. And it's a bit like Australia in this respect. Maybe it lacks something of the energy, dynamism and creativity of the United States. But on the other hand, there are many fewer guns, and it's generally safer to be there, and there is peace, order and good government. And that's the best answer I can give. I must tell you that we are increasingly in my court looking to Canadian decisions. The Supreme Court of Canada is a very distinguished court. And we look to American decisions and have since 1901 when our Constitution was adopted. But the Canadian court and the Canadian society is a very interesting place and very similar in some respects to Australia. Yes.
Since you are comfortable watching TV, reading newspapers and pushing a grocery cart, do you keep up on motion pictures enough to comment on how well the movie Kinsey did in your nation?
How well the film did?
Yeah, film.
Yes. Well, the film was very popular in Australia as it was in the United States, and I've heard people say, including in the last day or so, that they thought in some respects the film was unfair to Dr. Kinsey and unfair to Herman Wells, There was a suggestion in the film that on the second occasion Dr. Wells backed off in the support for Dr. Kinsey, which couldn't be further from the truth. I regard Herman Wells as a truly wonderful man. I wish that on my first visit to Bloomington, when Herman Wells, though very ill, was still alive, I had had the privilege to meet him, because he truly was a remarkable and noble spirit. He was one of the persons who helped to found UNESCO, and he was not only an American, but he was a globalist. And in every way, he was a person with a big mind, that was ahead of his time, and a great, valiant defender of intellectual freedom and research. So I think maybe in that respect the film was not entirely fair. And I could understand that members of the Kinsey family, hearing about the sexual lives of their grandfather, would feel as we would all feel if we had that. That's one of the perils of being a great person, that you are then reified and people will know aspects of your life that in most cases are not known. But I wrote to his daughter Anne and said to her what I've said to you, that he had a profound effect on my life and on the life of millions of people around the world. And in that sense, he was one of the master spirits of the last century. And I think that is a great gift of a human being to give to future generations. And you see criticism that this statistic is wrong and that statistic is exaggerated and so on. There may be some truth in particularities of that kind. But this man who had the obsession about gall wasps turned that obsession to the human species and applied the same technique. He really had a big impact, and this university had a big impact. It's very important for a foreigner to come to tell you what a huge impact he had around the world. And I think we can trace the events of the last 50 years, which is just the blinking of an eye in terms of the history of civilization, and see the changes that have come about. And I think it was the confluence of his research and the American media that made it very global all of a sudden. So I think the film captured those aspects, and on the whole, I think it was a very good thing for Kinsey and this university. Yes?
When we talk about human rights, fundamental human rights, we can't not talk about it. We have to talk about it in a global, international sense because we're talking about human in general. When we talk about international human rights and we look at different laws across the world, we often, especially in terms of sexual minorities, we often hear the words ethics or morality, which is often in the Western culture defined by, or at least impacted by, Christian ideals. What do you think, I don't expect you to tell the future, but what do you think, in your opinion, would be the influence of Christianity to the world and vice versa, the world to Christianity as we progress more into the discussion about human rights?
Well, I was brought up as an Anglican, Episcopal, and I still regard myself as a Christian Australian. And when I see my bishop saying things that I don't think are nice, I write him a very quiet and respectful letter, and he writes me back a very quiet and respectful letter, which we both write in the name of Jesus Christ. And I think it's very important not to pose an alienation between sexual minorities and religion, whether it's Islam or Judaism or Christianity or Hinduism or Buddhism or any of the great religions of the world. I recently served on a committee of the International Bioethics Committee looking at stem cell research. And this is one of those hot button issues in many societies where very strong religious and other views are put forward. And the chairman of the International Committee was at the time a Japanese. And so I said, well, we've got to look at the religious views on this subject. And his response, as a sort of Buddhist response, was, why are we looking at religion? This is a matter of ethics, and ethics is not religion. But I explained that in many societies, as a practical matter, you have to look at religious instruction, even if in the end you don't accept it. Now the problem was, once we did that there was such diversity between the religions on issues like stem cell research. Only some Christians believe that life begins at the moment of conception. Some leading Roman Catholic theologians have written that it begins when the primitive streak appears, which is about, I think, 14 days after conception. Some say it occurs at a later stage. Judaism normally teaches that it occurs after about 28 days. And Islam teaches ensoulment occurs after the first trimester. And therefore, if you sit down in a group of the world, as distinct from in your own country, which is in America basically Christian, as in Australia, you find it very difficult to just insist on your point of view, because your point of view will not be accepted by people of other faiths. And so I think the search now is for the wisdom of religion to feed into decisions, in an expectation that religion will itself adapt and change to modern scientific knowledge, but looking increasingly to the principles of universal human rights as a kind of attempt to express in a way that will speak to all human beings the basic principles that bind us together. And it is true that most religions have changed their view over time when science shows that their interpretation of their scriptures cannot stand with science. As, for example, the notion that the world was created in 7 days, or the notion that it was created 5,000 years ago, or other matters that the sun circled round the earth. Matters of that kind, which were so hotly contested in earlier times, are ultimately established by science. And that, I think, is the injection of a scientific element into this debate of sexuality, which has really changed the debate. It hasn't changed it overnight, and I saw in yesterday's USA Today the votes in the referenda in the States about same-sex marriage, and in some, Missouri, I think it was 82% were in favour. So there are very strong feelings on particular issues. But the same article revealed that that issue is not such a hot-button issue now as it was a year ago. And the day before, I saw in a Chicago paper on my way here the new head of the AIDS program in the United States of America being sworn into office by Condoleezza Rice, the Secretary of State, with Mrs. Bush looking on in a friendly way, and Condoleezza Rice acknowledging the man's partner who was standing there in the photograph, and acknowledging the partner's family. So things change and things will continue to evolve. And I think gay people who have a lot of time in their little brains to think about this issue have to remember that straight people don't think about it quite as often or as much. and therefore that it's something that takes time to evolve. But in the end, you cannot stand against the voice of science. And in the end, I believe we are genetically programmed to accept that. And so that is a voice which Kinsey tapped. And that's why his work is, I think, so important and so undervalued in Indiana and in the United States. There may be reasons for that, and I've had various reasons explained to me, but I consider him to be a great Indianan and a great American and a great world figure. Yes, Justice Stevens.
Justice Kirby, we're grateful, as we always are, for your many wide-ranging insights. I'm interested in the what you describe as this new fault line, or maybe not new, but this fault line between civilizations, and two quick questions on that, if I might. You indicated that the attitudes of civilizations towards homosexuality differ greatly depending upon how democratic or how totalitarian they are. And I'd be interested for your explanation as to why that is so. My second question is that in identifying the issues that define this fault line, I believe you mentioned on a couple of occasions your litany was gender equality, divorce, contraception, and homosexuality. And I wondered if you would include abortion on that list, and if so, maybe reflect on how the abortion debate, which has greatly divided this country, plays into your analysis of this fault line between civilizations.
Well, first of all, this is not my thesis as such. It's the thesis of Professor Engelhardt of the University of Michigan and Pippa Norris of Harvard. And so in my paper, I've got a new fault line, but I put a question mark, because of course there are some people who say talk of fault lines is talk of the grand theory, and that's in truth, as Kinsey taught, a human attempt to impose on the complex reality a pattern that puts nations into boxes, and like human beings, nations don't quite so readily fit, and therefore that it's not entirely accurate. But it's something to conjure with and to think about, because we're all puzzled, I think, in the world after the 9/11 events as to how we can get peace with democracy and justice for everyone in the world. And I think that is the aspiration of the American people, and I'm sure of the Australian people. So that it's a thing we've got to think about, and it's the thesis of these two scholars. As to why you get these various issues and whether they're completely linked to autocracy, I think there is a feature of democracies that they are more questioning, and they're more likely to question received wisdom and less likely to accept truth imposed from on high down on the bottom. It's like a bottom-up notion of governance as distinct from a top-down. I feel pretty sure that if we were in Iran today, you couldn't have this meeting. You couldn't have this discussion. You couldn't have difference about it. It just wouldn't be tolerated. I went to a meeting of the International Bioethics Committee in Iran, and I did refer to the issue of homosexuality, and a couple of mullahs and others came up to me later and they said that is the first time we've heard that subject discussed in Tehran in 25 years. And so it's not something you can talk about, and unless you can talk about things, you can't develop your thinking and change opinions and adapt to the reality that science suggests. As to abortion, it's true that Engelhardt and Norris include that amongst the fault line issues, and they include it as a sort of subcategory of contraception. And that's of course how some people view abortion. Others, especially those of a Christian upbringing, are not inclined to embrace that view and say that in this day and age there's no need to have abortion as a means of contraception. But they included amongst the issues, and my paper refers to this article and where it can be found. It was published in Foreign Policy, and it's a very thoughtful article based on a lot of research by these two scholars. I've mentioned abortion with contraception, but I do realise that it raises a whole series of other issues that may be even more divisive than questions of homosexuality are among some people. There would, for example, be many Catholics, I would think, who would be relatively relaxed, increasingly so, about same-sex relations, but feel very strongly about issues of abortion. In Islam, there would be strong feelings about abortion as well as homosexuality. So it's a matter of looking at these issues and seeing where they play out in the value systems of the societies involved. In Europe, and I think I'd have to say in Australasia, abortion is not on the current agenda. It's not being discussed because judicial decisions interpreting criminal codes have effectively made abortion available in much the same way as in the United States. So it's sort of off the radar. But whether it comes back on the radar in the United States of America with the new composition of the Supreme Court is another ground for watching the space. Are there any other questions or comments, including adverse comment? Yes. We need Justice Scalia here to brighten things up.
In your opinion, to what extent the decisions of various national courts or the interconnection between or among various national courts decisions is changing the mind of these courts in specific issues such as abortion or homosexuality? I mean, this networking strategy that many national courts use changed decisions.
Well, this is a very controversial subject in the United States. It's much less controversial in countries like Australia and Canada because for 100 years or more we've been using foreign decisions. I mean, it's not a big deal. We go for a century and a half to the Privy Council in London because we were bound by their decisions. So we had to look at foreign courts, and in looking at them they would be citing decisions of the Supreme Court of Canada or the Court of Appeal of New Zealand or the Court Appellate Division of South Africa, and so we have sort of been programmed to looking at international comparative law, and it's not a big deal. I think the big deal is if you start to think that because a foreign court decides something, that therefore you are bound to decide the same way. But nobody has said that, certainly not the justices of the Supreme Court of the United States. They've simply looked to what's going on elsewhere, and specifically they've looked to it in the context of the provisions in the American Constitution forbidding cruel and unusual punishments. Now, if you take the view that cruel and unusual punishment in the United States Bill of Rights means only cruel and unusual punishment in the United States, then that's illicit. But if you take the view that it talks of cruel and unusual punishment, period, then it's legitimate to look at what's happening in the world, and that's basically all they've done, and then they've reached their own conclusions. And in Lawrence and Texas, they looked to what had been happening in the European Court of Human Rights, not to bind them, but simply to inform them of the world in which they were interpreting the Constitution of the United States. The longer I sit on a constitutional court, the clearer it is to me that you can't take a word out of context. To interpret, you have to interpret in context. And the idea that the context of your constitution is only your nation is one that is curiously unsuitable to an age of the internet and to cyberspace and to the jumbo jet that brought me here in a day and a half, and to global problems like AIDS and so on. I mean, we now read our constitutions in the context of the world. They speak to us of our nation, but they speak to the world of what our nation is and what its values are. So I don't really see the big issue. And in Europe, when I go each September to Yale and meet with judges of final courts, including Justice Breyer of the Supreme Court of the United States, amongst the rest, Justice Breyer usually retains a discreet silence on some of these issues because they may come before him. But amongst the rest, it's not a big deal. They're looking at each other's jurisprudence all the time, not as a precedent to bind, but as a contextual matter to understand the issue and problem that's before the court, and what a lot of very clever people in other countries have said and done about the issues that are before their court. Yes?
As I understand it, Kinsey liked to refer to the human animal and had an interest in animal behavior. Might one of his longer-term legacies have to do with an interest in animal rights internationally?
Well, I certainly hope so, because it's interesting when you study animal rights how in the law they began in England with protection of domestic animals, and then that began to spread to the animals we eat. It had to have some relation to Homo sapiens and to be worthy of protection. But I think that in the modern age, the writings of my fellow countryman Peter Singer and others, that we are coming closer to a realization of the links between all sentient beings, and certainly all mammals. I mean, if you have a little cat and you have a love for the cat, and you see the cat living and breathing and having rage and anger and pleasure and purring, you realise that this is a sentient being with a life and a worthiness of protection. And increasingly in Australia, concern about live sheep exports and the export of cattle, and cattle being in the outreaches of the deserts. This has become very active concern, and more people, as they begin to understand that in many ways we are unique because of our consciousness and our capacity to think about ourselves and to think about moral principles, but that in turn helps us to see our link with other creatures. Maybe not with gore wasps. I think I might draw the line at gore wasps, though I think if Dr. Kinsey were here, he would probably put up a sterling defence of the gore wasp and its social life and so on.
Well, I wonder if you'll join me in thanking